patents being a backdoor to it, like we talked about earlier, we have these sorts of like FRAND licensing provisions. So you have these standard setting organizations. It's like Google and Apple and Sony and whoever else get together, and they're like, here are what the tech standards are going to be. Or in that example earlier, glass blowers get together, and so that they can like lawfully cooperate on this stuff instead of unlawfully collude, they get together and they're like, here are all the like glass blowing standards. Those organizations then are based on the standards established by those organizations. Any of the technologies and processes and stuff that are patented that are necessary in order to kind of meet and operationalize those standards, right? So any of the things you would need for USB, any of the things you would need for like reasonably good quality glass blowing, whatever, become what are called standard essential patents. There's abbreviated SEPs. Standard essential here meaning essential based on those standards, right? And so that set of patents is then subject to FRAND, fair, reasonable, non-discriminatory licensing terms, which means, unlike with a regular patent, where you can do whatever you want with it, here, when somebody comes along and wants to use that process or use that technological standard or whatever, you have to make it available to them to license from you. They have to pay you, but you have to make it available to them in a way that is fair, as in can't like pick winners and losers in the market, can't make it available to some people and not others. Reasonable, and non-discriminatory, meaning something broadly similar. And reasonable in the sense that I can't be like, you have to like pay me an exorbitant amount of money that would not possibly be possible for you to sustain while still profiting, because then it's as though that licensing requirement didn't exist to begin with. Does that make sense to people? Yeah.
If there's like a breakthrough in glass blowing technologies, would the SO like meet again and decide if that should be included in like the standard process of glass blowing?
Yeah, so my understanding is yes. I will confess I'm like not super deep in the weeds on how the determination is made about which things need to be incorporated into those standards. My impression, based on like the amount that I have read / what I do know about this, my understanding is that for the, like, let's say you come up with a new innovative way of blowing glass or whatever, you are free to patent that. You do not need to, you're not like required that to make that available to people or whatever. If we begin to enter into a circumstance where you are colluding with other companies and you're establishing that as sort of an industry standard, and you were to not explicitly make that one of these standards and then therefore allowed to be subject to standard essential patents, then you would be subject to a lawsuit. I'm not sure whether that would be like a U.S. antitrust authorities thing. I think it would be, or whether it would instead be the people who are being harmed by it can sue you, or both. Probably both. But does that make sense?
Yes.
So like yes and no, and it's sort of a balance. It kind of shifts over time depending on how like what you're doing with it. But as long as it's like, I came up with this thing, this gives me an advantage of the market, I am like taking full advantage of that, that is fine. It's only when you veer into this thing is an industry standard and we are now excluding new people from entering that industry standard that it becomes a problem. Yeah.
Under FRAND, is there like a price limit or a cap on how much the patent can be sold for?
Not like a specified dollar amount that always applies or whatever, because what's reasonable depends on the context, right? It's like how much money are you likely to make from this thing, whatever. And so I think that, so like when somebody is like, this is not being made available in a way that complies with NASA provisions, they would then bring a lawsuit about that, and the court would adjudicate that based on all the prior kind of case law in that area, the relevant, like any relevant guidance that agencies have issued about that particular area based on subject matter experts, all that kind of stuff. Does that make sense?
So when a patent becomes an SEP, is that done in court, or like how is that brought to the government's attention?
Yeah, well, so I think those are two slightly different questions. I'll start with the latter, like how that brought the government piece. For the most part, like the USPTO and any kind of sector-specific regulators in a given field, the executive branch, are dealing with these kinds of things constantly. They're like constantly in the mix on like what are tech companies doing or whatever. In terms of when, and so the majority of the time, there isn't actually a need to enforce any of this because like everyone understands this is what the rules are. Government's sort of involved in kind of a collaborative way with industry and figuring out these standards and then ensuring that those patents are made available. When there is a need for an enforcement action, yes, that like sometimes that will initially happen by somebody coming to the PTO and being like, hey, this is a thing. The government steps in and is like, if you don't fix this, you're gonna have a lawsuit in your hands. We think they'll win, whatever, and they'll like sort it out on the front end, and the industry, the person sitting on the patent or refusing to make it available will change that before it even needs to go to court. In the event that they don't, then yes, it would be resolved in court. There would be litigation about it. The court would be like, yes, this should be a standard essential patent. It isn't being properly covered or like properly made available. You need to fix that and also like pay people compensation. Other questions? Great news. Okay, so two other phrases that I want to acquaint you all with here, just so again, when you like see this jargon, you aren't like, what's going on? Grant licensing. We then have like standard setting organizations and standard development organizations that, as the name suggests, set/develop standards. Standard essential patents that, as the name suggests, are essential based on those standards. Two other phrases that you are likely to hear are patent holdup and patent holdout. Does anyone know what either of those mean? Okay. So patent holdup is a situation in which something is a standard simple patent and the owner of that patent is not making it available to people. It's exploiting the fact that, so like an organization sets a standard that says everyone must use X thing. Obviously, the fact that a given technology is the required standard, like let's say USB, which isn't actually an example of this because I think it's open source, but let's assume it weren't. A standard, a given organization is like, everyone has to use, like an industry org says everyone has to use USB. The person who owns the patent on USB is like, that obviously gives us a de facto monopoly on this thing, so we're going to charge artificially high rents for people, right? It's like, we control the only supply of this thing. That's patent holdup, which, as just discussed, is a no-no, the solution to which is the court will apply this set of principles and be like, cut it out. The second one, patent hold out, is on the end of the implementer. So it's the converse of this third person. Whereas this is the owner of the patent is making it unavailable. In this case, let me double check this is right. Yes. Yep. So in this case, what we're talking about is somebody who is trying to implement one of these standards, so like somebody in that industry that requires a patent. Instead, so like patent holder tries to make them available on fair and reasonable terms, and the person basically just like refuses to negotiate with them, and is like, instead of engaging in a meaningful negotiation over like what is reasonable, what are the rates, and then like agreeing to pay, they're just like, no, we are not going to engage, and either infringes on that patent, right? Is like, we're not going to pay the licensing fee, we're just going to use the thing. Or more commonly, and the reason this is like this language of holdout is used, is sometimes people will do that as sort of a delay tactic because, to put pressure on the patent holder because of the fact that if this were to go to court, that ends up being like really costly and time consuming and stuff to litigate, right? It's like they have to hire a bunch of lawyers for it and whatnot. And so it's unlawful. Like a thing that happens sometimes as a potential problem and it's not allowed is somebody who needs the thing for, in order for me to give them the standard, holding out on negotiations over the thing in an attempt to like coerce or pressure the patent holder into just like giving up or giving them a better deal than is actually reasonable or whatever. So this kind of like, it must be reasonable type premise to some degree cuts both ways. Does that make sense to people? And I will also highlight, yet again, we see this like balancing actively, right? It's like, why do we care about it going both ways? Because we want people to be developing these technologies that are useful for these things in the first place. And if they can't ensure that they will be able to make some reasonable amount of profit from it, then they will not do so. Yeah.
Or like, if someone develops a new patent that is like revolutionary, wouldn't it be in the interest of the SSOs and STOs because they're in the industry to make that standard practice to force the old owner of it to give it out to them for their SSP?
Yeah, so I mean, in some cases, yeah, something will be adopted pretty quickly as an industry standard. That is not a bad thing for the patent owner, though, because then what they've actually said is everyone in this industry needs to use your suite of technology, which is itself a great way of producing meaningful returns on innovation, as long as the licensing terms are reasonable in a way that like balances their interests instead of just favoring the person who's trying to like license the thing. Does that make sense? Yeah.
So the patent holdup is on like the SCP owner side, and then a patent holdout is on the SCP buyer or SCP.
Like, yeah, the person licensing it / implementer is a phrase that we'll see a bunch, but yeah.
Wait, so patent holdout is like when people that are infringing on like your patent don't engage with like.
It's where you are the person who owns the patent that is part of this industry standard.
Yeah.
I am the person who, in theory, is trying to license that patent, and I refuse to engage in kind of good faith negotiations over those rates and establishing a licensing agreement, and instead either just like charge ahead and infringe on it, or just like keep holding out and dragging the feet, and then I'm like, they're not licensing it to me. That's no good. And continuing to insist on like an artificially low price is also no good because we need this to be reasonable for all the parties.
Question. You might have to shut the door so I don't get loud.
Yeah, sure thing. Yeah, I appreciate it.
I guess changing the provisions of how contracts could be written or what they could be due considered topical under that. Under this scenario, it's like, I guess if licensing is being determined by contract,
I would think that's a good question. I haven't cut cards on that specifically, but I would not be at all surprised if protections. Yeah, I mean, it depends on what the word protections means. I would think so, though. Yeah, I feel like that would be pretty apt if you have the right definitions. It's good cue. I do think that bucket of Fs would be pretty good. Other questions? Okay. One miscellaneous thing, we can like chat about this more later. This is an area where /contract law in general is an area where the states can do more than they can on most areas of this topic. So that's a thing to consider. Yeah.
that is state.
Okay.